Good afternoon. I welcome you all in the 1 month faculty development program initiated by the Faculty of Law, Integral University, Lucknow, under the association, under the Aegis of Human Resource Development Center, Integral University, in collaboration with the Association of Indian Universities. On the theme, integration of intellectual property rights principles into teaching, research, and professional activities. We started this faculty development program on 2nd of September, and all the way through, the entire efforts of the organizers of this faculty development program have been to inculcate the practices of the intellectual property rights into the basic aspects and the basic practices under the teaching methodology, research, and the other professional activities related to this pious job profession. As of the entire modules, our modules have been divided into the various segments dealing with the aspects of the intellectual property rights as per the very inculcation in the teaching pedagogy. The factor being that this particular module 3 we are having today is on the technical session related to the commercialization of research, the scope of trademark rights in research. Today, with ourselves, we are having a very prominent resource person from Dr. Ramana Loya, National Law University, Dr. Prasenjit Kundu, sir. Dr. Prasenjit Kundu is associate professor in the National Law University, Lucknow. He has been one of the very prominent persons in undergoing and leading the arbitration subject and the commercial law subject under the National Law University premises. He has completed his PhD from Dr. Ramana Loya, National Law University, along with his LLM from University of North Bengal, as well as his LLB from the same alma mater. He has his publications in various prominent law journals, along with the RMLNLU Law Review, RGNLU Journal of Dispute Resolution Mechanism, as well as the various journals of the UGC HRDC in collaboration of the University of Delhi. He has been the resource persons in various prominent skill development and training programs and commercial practices programs, the development of digital library programs. He has been the resource person there. He has been participative in the workshop on legal proceedings and court cases with focus on the commercial disputes. Hopefully, the resource person would be totally igniting light with regard to the various aspects of the commercialization, which has entered into the various research activities undertaken by the faculties and the research scholars. Hoping for the best, Dr. Prasenjit Kundu, I welcome you for undertaking this particular faculty development program session.
Thank you, Dr. Seema. It was a wonderful introduction. I was eagerly and anxiously, listening you. The kind of, description which you have given, I don't know whether do I deserve it or not. A big hello to one and all everyone present here. I'm Dr. Prasenjit Kundu. I'm faculty of Dr. Ramana Loya National Law University. I have got two important, areas to discuss in this technical session. As all of you can see, the first topic would be the global perspectives on IPR, the international approaches to IPR in research. That's a very big concern for us, that the different, international approaches which we have adopted to IPR in academic research. And the subsequent topic which have been allotted is again, I would say, is a part of the initial topic, that is the commercialization of the research. Uh, in the course of the discussion, we would see like these two topics are actually connected, and dealing one topic would definitely open the door of discussion of another topic. So, without much ado, I start my presentation. The screen is visible.
Yes, sir. It is.
Okay, thank you. So, as we can see, that the two important areas of your research and your intellectual property rights, the application more precisely, I would say,
Sir, make
your
it on the full screen so it will be all the more visible, please.
okay. Vishwahan, एक minute. It's not full screen.
No, it's not full screen. Just make it as a PPT presentation.
Is this fine now?
Just a moment, sir. No, sir, it's
Full screen. Hmm?
on the top. On the top,
No, no.
there is a marker for the PPT presentation. Yes, sir. This one. Yes, yes.
Is it the
Fine, sir.
full screen
Fine.
now?
Sir, you continue with the presentation. It would be done.
No, but here I'm seeing that full screen.
Fine, fine, sir. You continue with the presentation, sir.
Okay. No, okay, I'll continue with my presentation, but please do let me know that whether you can see the full screen or not.
Yes, sir. I am seeing your material on the very screen, but the other icons are also visible. So that was the very reason why I was saying that. Whereas okay, it's completely comfortable, sir. You can start with the presentation.
Okay. Okay. Thank you.
Thank you, sir.
So as we can see, like we have two important areas to discuss here. One is the global perspectives on IPR international approaches to IPR in research. And the other one is the commercialization of the research. At the very outset, as I have shared with you people, like a discussion on different, international approaches of your application of IPR in research would definitely attract a discussion on your commercialization of research. So these two areas are interconnected. Now, it's a customary practice that whenever we, whenever we deliver a lecture on intellectual property right, we start with the definition of intellectual property rights, and we have a lot of definitions of intellectual property rights. This particular description of what is intellectual property and what is your intellectual property rights, I have chosen in the light of the discussion which we're gonna have in just 2 and 3 minutes. So I don't need to explain this definition of this intellectual property. You know, like any idea which we have or any design or any kind of invention, your manuscript. Important thing is like that idea which I'm talking about, that design, that invention, that manuscript which I'm talking about, must be the one which would ultimately give rise to a useful product and application. So that's very important part of the definition of the intellectual property when I gonna look into this intellectual properties application in academic research. So I would again like to draw your attention that any idea, design, invention, manuscript, any doesn't mean like any idea and design and invention manuscript, it has to be something, it has to carry that weightage and that credibility, which would be useful for kind of, some production or some application of that design, some idea, some invention, etc., etc. And at the right side, as we can see, like we have this intellectual property rights, and in the light of this definition of the intellectual property which I have described here, as you can see, I'm simply writing that your right, that if you are an inventor, so your right to derive economic benefit from your intellectual property. Your intellectual property means the idea which you have displayed, the design which you have made, the invention which you have made, the manuscript which you have produced. So if there is a right of yours to derive your economic benefit from this intellectual property, so that is your intellectual property rights. Now, having defined or having tried to look into this definition from this perspective, I must let you know one very important um, contention, that your intellectual property rights in research is a very crucial and your complex area. Why it is so crucial and complex? Because you would be seeing that different countries, they have adopted varying approaches to managing and protecting these intellectual property rights. So because we have these varying approaches of different countries in regard to this managing and protecting of your intellectual property rights, you see it is becoming very relevant when we are looking into the application of this IPR in your academic research. Now, here I'll be presenting you an overview of how some international approaches have shaped IPR in your academic research. I repeat, I'm gonna show you some kind of overview of how some international approaches are shaping the IPR in your academic research. So here is a look. Uh, I'm talking about your international approaches to patents in academic research. And I would also be talking about your international approaches to copyright in academic research. Now, I've chosen few jurisdictions because my topic, on which I'm supposed to speak, is the international perspectives on IPR. So definitely, I would be talking about the different jurisdictions, that how the different approaches have shaped IPR in your academic research. Starting with your United States, if you have a look at the existing system, in the United States, your research findings can be patented. Obviously, it has to meet with certain criteria, like like novelty, your non-obviousness, your utility, etc., etc. So these are the requirements which need to fulfilled in US legal system before your research finding gets patented, right? So it's very easy that in US it's amply clear that your research findings can be patented, but these research findings has to be in compliance with some of the requirements, as I just mentioned, that it must meet the criteria such as your novelty, your non-obviousness, your utility, etc., etc. And as you can see that we have this US Patent and Trademarks Office, USPTO, which are responsible in overseeing this process, right? Coming down to European Union. So in the European Union, you'll find the European Patent Office, that is EPO. And when you look into the functioning of EPO, this EPO would be providing a centralized patent granting process to any academic research. So this is EPO which is responsible for providing a centralized patent granting process to any academic research. And one very important point for European Union is, like, if your research output is being approved, it gets that approval of your European Patent Office, then uh, this is valid across any member states of the European Patent Convention. So there are a number of European states which are the members of your European Patent Convention. So kind of, patent which is being granted by the European Patent Office, that is valid throughout all these states, member states who are the members of your European Patent Convention. So that is something very important to look into it. Then we have this China. Now, when we look into this China's legal system, this China's system, it has become increasingly sophisticated with the focus of its fast tracking of certain application, including the application in relation to your academic research. Now, as I'm saying that this is increasing, and that system is very sophisticated, because this China system is, now recognizing a fast tracking of certain applications, including your applications in relation to academic research. And in China, you can see that we have your China National Intellectual Property Administration, CNIPA, which handles this, granting of patents. Now, coming down to India, we all know, like, we have this Office of the Controller General of Patents, Designs and Trademarks, that is CGPDTM. And this is the entire process of granting patent to the academic research is being managed by this Office of the Controller General of Patents, Designs and Trademarks, that is CGPDTM. And we know, like, India has this growing, patent system with specific provision for traditional knowledge and biodiversity. Looking into the Japan Patent Office is there. So this Japan Patent Office and the system which is prevalent in Japan, it is actually known for its rigorous examination of the patent, process. And this Japan has also participated in Patent Cooperation Treaty for your international patent applications. Looking into the international agreements, I have chosen 2 international agreements, as you can see, which are relevant for the discussion of your application of the IPR in academic research. One is the TRIPS agreement. As you know, this agreement is on trade-related aspects of intellectual property rights, which is administered by WTO. And this TRIPS agreement does lay down certain minimum standards for IP protection that the member countries must adhere to. We also have this Patent Cooperation Treaty, PCT. This PCT is very important because this would be providing a unified application process. And because this is providing a unified application process, so by this way, this would be facilitating any kind of process of applying for patents internationally. So Patent Cooperation Treaty is actually for ensuring a process for granting patents internationally. So this would be facilitating the process of applying for patents internationally. So these are some of the international approaches to patents in academic research, like the US legal system, European Union, the China, India, Japan, and your international agreements are there. Now, coming down to your international approaches to copyright in academic research. Now, if you look into the international approaches to copyright in academic research, so these approaches are shaped by a blend of, as you can see, the national law, the international agreements, and some of the evolving practices in the research community. I repeat, when you look into these international approaches to copyright in academic research, you would be seeing that these approaches are actually shaped by a blend of your national law, your international agreement, and some of the evolving practices in the research community. Now, when you look into the international agreements, I have chosen 2 international agreements which are quite relevant when you look into the application of copyright in academic research. The first one I'm referring is the Berne Convention for the Protection of Literary and Artistic Works, which was entered into 1986. Now, this Berne Convention, this treaty, what you can say, is actually a cornerstone of your international copyright law. So it would be establishing your minimum standards of protection. And what is very important for us to understand, that this Berne Convention, this treaty, would be mandating that any member countries to recognize and enforce your copyright protection of works which are created in other member states. Are you getting? So this convention, this definitely laying down some minimum standards of protection, and this also mandates the member countries, whosoever is that member of this convention, they must recognize and enforce the copyright protection of the works which are actually created in other member states. So when you look into this convention that is on literary and artistic work 1986, so this literary and your artistic work will definitely include your academic text, right? Now, the other international agreement treaty which I have referred, as you can see, is the World Intellectual Property Organization treaties. Now, when you look into this WIPO, that is World Intellectual Property Organization, so this WIPO is administering several treaties which are relevant to your academic research. So I have, referred to such relevant, treaties which are very relevant for your academic research. One is the WIPO Copyright Treaty, WCT. So when you look into the functioning of WIPO Copyright Treaty, it is actually extending a protection to the digital and online environment, right? And when you look into the WIPO Performance and Phonograms Treaty, this is very interesting because this treaty would be addressing the right of the performers and the producers of sound recording, right? So this treaty would be relevant for any kind of audio visual academic content. So these are some of the international agreements which you can take note of, which you may take note of in order to understand the different international approaches to the IPR rights vis-a-vis to the patent rights, to the copyright rights, how to apply these rights in your academic research. We are going to have a detailed discussion, and we would see the commercialization of your academic research and the application of different principles, etc. These are some of the informations which I thought that I would be sharing with you at the very outset of our discussion, right? So again, to summarize the things that we talked about, the international approaches to your patent rights for the academic research, and I also talked about your international approaches to the copyright in the academic research. So international approaches to copyright in the academic research, I said, as you must remember this thing, that this is actually a combination of different international treaties, that is international agreements, your national laws, and you would also come across some kind of evolving practices which are being followed in your research community. So copyright protection, for the matter of the copyright protection, these international treaties are there. And when I talk about your this evolving practice, I actually meant to refer your open access movement. So many of us are quite well aware of this open access movement. Now, this is also very important for granting patent to academic research and the issues which are coming up in granting patent in academic research, right? Sorry, the copyright. Now, open access movement, when you look into this open access movement, you can definitely say that this is a significant trend in the academic research, and the aim is to push towards your academic open access publishing. So the very object of your open access publishing is what? Is to make your research outputs freely accessible to the public, and it often involves different approaches to the copyright. So you can see that when we look into this open access movement, when we look into this open access publishing, the very aim of this open access publishing is to make your research outputs freely accessible to the public. So we have also identified some kind of some different approaches to your copyright in case of your open access movement. So you see, like, Creative Commons licenses are being there. You see green open access is there. You see gold open access is there. Now, Creative Commons licenses, we all know about this Creative Commons licenses. We know like 6 licenses are there, and there is that 7th one which we call that zero domain, and the that is a public domain. And this green open access is very interesting. Here you will see that the authors, they would be depositing a version of their article. The version of their article means that would not be the final version of the published article, right? So they would be depositing a version of their article, means it could be the preprint or the post-print version of their article, and they would be depositing this version of that article in any institutional or subject repository, right? Now this version which they are going to deposit in that repository, that could be the institutional repository, that could be the your subject repository, so that is accessible. But the final published version, mind it, that the final published version of that article, that would be beyond a paywall. That means to access that final published version, you'll have to pay an amount. So that is the green open access to your, that is again a kind of stage to be followed in the open access publishing. So that's a measure which been taken up. Now again you see that gold open access. Now in the gold open access is very again something which we are very familiar with, that here the articles to be published in the open access journal, right? So the articles, it's not in any kind of institutional or subject repository. This is to be uh, this is to be published in your open access journal, right? And the cost to be covered by the author's fees, because we know like there are a lot of journals which would be charging your article processing charges. So that cost is to be covered by that expenses, that expenses is to be covered from that cost. And you would be putting your journal, sorry, your article in that open access journal. So you will have an access to that final published version of your journal, which is freely available to the public. So these are the different stages when you look into the copyright issue and your article in the open access domain, right? So open access movement is very significant trend in the academic research. You must look into this thing, like what kind of open access publishing is there. It could be your Creative Commons licenses, it could be through your green open access, it could be through your gold open access, and what is the different measures which to be taken up for different kind of open access publication. Now, open access publication, for open access publication also we have some major developments in this open access publication. And the first one I must mention is the Budapest Open Access Initiative, BOAI, right? So this is launched in 2002. Uh, this is one of the most influential statement, and it would be advocating for open access, right? And the very important task of this initiative, that it would be outlining the concept and aim to increase the availability of scholarly literature. So it is aiming to increase the availability of scholarly literature, which is prevalent in the very language which is being used in that in drafting that initiative. So you also have this Public Library of Science, PLOS, that I think it was founded in 2000. And this is also a very prominent open access publisher. And and you can say that this is a very major proponent of the movement, that is your open access movement I'm talking about. And finally you can also come across your Plan S. This is very interesting. This is an initiative of Coalition S. That Coalition S is what? This is actually a consortium of research funders, right? Now this initiative is called Plan S, and I'm saying that this initiative is being taken up a Coalition S. And what is Coalition S? Coalition S is a consortium of your research funders. Now, this initiative mandates that if the research is being funded by your public fund, then it must be published in an open access venue. Are you getting my point? So if your research is getting funded by the public fund, is public grants, through the public grants, so it must be published in an open access venue. So these are some of the international approaches to IPR in research. So all the instruments and the international documents I've been talking about have been laying down different provisions in relation to granting of IPR rights in the academic research. So uh, after this, now we would move to our main discussion, that we are trying to find out the different issues which are there in your intellectual property rights in research. Now, before again I embark on this topic, I would like to say, like, what I have seen, like many of us, many of the faculties even not knowing, even not aware of the issues which are actually involved in the question of your intellectual property. Now, what intellectual property, in the light of the discussion, we all know, like, this intellectual property is nothing but the output of your human brain, that is that idea. And what we know about this thing, that traditionally, that ideas have been owned who have produced them, isn't it? So when we talk about the intellectual property rights, we know, like, this is what, this is actually the output of your kind of any idea, your the output of your human brain. That could be your any kind of idea. That could be any kind of scripts. That could be any kind of manuscripts. That could be anything, right? But obviously, this is something coming out of the human brain, intangible, right? So, and what I've shared with you just now, that traditionally we know, like, these ideas, the ideas have been owned who have produced them. Now, but what we are seeing very recently, that the universities. So, okay, before again I talk about the university, role of the university. So we all must agree to this thing, that when we are saying that your intellectual property is just the outcome of your human brains, so therefore the idea is to be owned by someone who has produced them. So definitely, when we're talking about the academic research, so obviously the researcher or the professor who is carrying on that research is definitely the owner of that research, isn't it? Because the ideas, the designs, the kind of inventions are made out of the brains of those individual professors. So there should not be any denying of this fact, that whenever we talk about this intellectual property rights, because we have analyzed this intellectual property right in such a way that we have come to this conclusion, this is nothing but just a kind of output of the human brain. So output of the human brain in the shape of an idea, in the shape of an art, in the shape of an work, in the shape of an manuscript, any invention, so must be belonging or must be owned by someone who actually have invented it. But now I am saying that what we are seeing, that recently the universities, the higher educational institutions, they've started acting like corporations, and they're attempting to claim the ownership of professors' ideas in order to market these ideas. Am I clear to you? So now what is happening, that even if we accept this part, we know, like, these ideas are owned by those people who have produced them, right? Still, what we can see, that the universities are making an attempt to own these ideas, to own the ideas of these professors. Why? In order to market these ideas. Now, what we can see, like, this attempt of the university to have an ownership on the ideas of the professors, this would be having several consequences. And to be precisely, I must say that this would be having, if we analyze this attempt and the consequences of that attempt, that we would be seeing that this kind of change would be having a devastating consequences for the academics. Now, just now I talked about that change of ownership, right? Because the universities now attempting to have that ownership. Now this attempt, or supposedly that ownership, is now being transferred to the university. So this change we are talking about, this change will have severe consequences in the academics, as I just said to you people. And if you look into it, that this is having kind of effect in what way, that this kind of market based strategy, because I just shared with you people, like whenever we're talking about this ownership to be transferred to the universities, the universities are attempting to have this ownership on these rights in order to market these rights, right? So if you look into this market based strategies, so this would definitely going to abridge your academic freedom in short run, and the far reaching consequences which you would come across, that it would diminish the human knowledge base. So look into the steps which we have been talking about. We've been talking about that IPR rights. We know like this is something generated from the human brains. So somebody who produced that idea must be the owner, and that has to be there, right? But at the same time, you see, like there is an attempt of these universities to have that ownership of those ideas. And now we can see, like if we go in deeper discussion of this process and the consequences of that process to be adopted, so we see like this would amount to a bridge academic freedom. And I would also show you that how this gonna diminish the human knowledge base in the long run. So now let's move step by step, and I would confine my discussion to US legal system, because I've been interested with this task of talking about that international perspective. So we cannot have a discussion on different jurisdictions at a time. So for the convenience of the discussion, I would be referring to your US legal system. I would try to show that what is the status, that how this the application of the IPR into academic research is getting shaped there, like the IPR rights, that is the rights of those professors who have actually invented something, that product, right, that manuscript, that research, etc., that article, etc., etc. How the how the law in US has shifted that ownership from the professors to the university educational institutions. And then we would see that how university is busy in going for licensing of those rights to the private firms, and therefore how there is a commercialization of your research which is taking place in US, and what is the impact of that commercialization of the research in the academic research. So are you, I'm sure like you're very clear with the outline of the discussion. So we would be looking into the transfer of that ownership. And I'm saying it again and again, the transfer of the ownership is from the professors to the universities, right? Then we would see that how university, after being owner of those rights, is going to market, is going to sell those rights in the market, right? So how they are going for kind of transferring those rights to the private firms in return of the money or the royalty, etc., etc. And then we'd see that how this is. Hello. हाँ. हेलो. हाँ. अच्छा. हाँ, साइड साइड चेंज नहीं हो रही है. तो कौन सा स्लाइड दिखा रहे हैं अभी? हाँ. अच्छा. अच्छा, स्लाइड्स नहीं दिख रहे हैं ना अभी. अच्छा ठीक है, मैं देख रहा हूँ. ठीक है. ठीक. Now it is visible, Dr. Sima. Can you hear me? Hello, hello.
Yes, sir, it is visible.
Is this visible now?
Yes, sir, slide number 8.
Okay, 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 okay. Okay, just a minute. If now I go for full screen, is it visible now?
So the full screen is not visible.
Acha, full screen is not visible. Now is this is
Yes.
visible, right?
Yes, sir. So can you please
Okay.
change slide once? Any slides? Yes, sir, it is visible.
Hmm. This is visible now?
Yes.
Visible,
So can you
right?
please click it? Yes, sir, it is visible.
Okay. Okay. So we were here only. Okay. I was audible, right? Hello.
Yes, sir, you were. So we can hear you. You can continue now.
Acha. Thank you. So we were talking about your change of ownership in IPR and its effect on the academic research. As I have just stated, you people, like how this ownership is getting changed, because initially the professors, the researchers who actually invented that research is considered to be the owner because that idea is produced by him. But at the same time, now I'm saying like there is an attempt of the university to have that ownership on that IPR rights, and thereafter we see like there is an attempt of that university to sell it out in that market. So ultimately we would be seeing that when we're looking into this application of the IPR in the academic research, we would be seeing that there is a kind of commercialization of that research. So now we are going we would be going step by step, and we'll be talking about these three important aspects which I'm showing on the slide, that we will be talking about your change of ownership in the IPR, and you would see that how in the short run it is actually abridging your academic freedom, and we would also see like how it is diminishing the human knowledge base in the long run. So as I said, like I'm confining to the US legal system because like I'm supposed to speak on the international perspective, and it would not be feasible to speak on different legal systems. So I'm sticking to US legal system, right? So when I look into this US legal system, okay, now when we look into this US legal system, as we can see, we have two important legislations. One is the Bayh-Dole Act, that is a Public Law Act 96/517, and the other one is the Public Law 98/620. Now, the first legislation was enacted in the year 1980. And by enacting this first legislation, the US Congress gave university the right to seek patent for the research outcome which is made by their faculty when especially the research was being carried on with the support from the federal fund. So be very clear that this legislation was being enacted, and it gave the power the university right to seek patent. Right to seek patent for what? Right to seek patents for research outcome, especially for which research outcome? The research which was being carried on with the support from federal fund. So if you look into that legislation, which was long back enacted in the year 1980, the first legislation I'm talking about, that Public Law 96/517, if you look into the motive of that legislation, right? So it was economic, because this was to facilitate the commercialization of your potentially valuable discoveries in the university research. Now, if you look into this legislation and the historical backgrounds before this enactment, yeah, the government, that US government used to own the patents which are stemming from any kind of federally funded research. Now, in those days before that legislation, when I'm saying that your government was owning that patents which were stemming from federally funded research, the universities could obtain these rights only through a very time consuming process, and a little licensing used to take place. Now this law, if you look into this law, this is actually empowering the university to seek and also to own patents, and also allow the universities the right to license their patents to firms. Now, this is the first legislation, and with the enactment of the second legislation in the year 1984, what we can see, like there is a kind of huge rise in the act of this ownership of patent rights by the universities. And we also can see that there is a huge work of licensing these rights to the private firms. Now, the effect of these two legislations, which was exclusively aiming transfer of the ownership from the professors to the universities, and allowing these universities the right to license these patents to the different firms. So these two things we need to take into account. One is transfer of this ownership from your professors to the universities, right? And the second one is your universities getting a right to license these patents to the firms. Now, when you look into these two legislations, after the enactment of these two legislations, as I'm saying, that there is a sharp rise of patenting in the universities. Uh, we can see, like in almost all big universities in US, like there is a special office which is devoted to this task of your patenting, licensing, or any other form of your technology transfer from the university to the industry. So now the gradual development is like in the universities, along with the research cell, you will come across the office, a special office, which would be devoted to the patenting, licensing, and any other form of your university industry technology transfer. Now, what is the effect of it? Like companies, the corporations, they started funding the professor's research, and in return of an exclusive right to that research. So information which traditionally we understand, which was actually a free flow in the academic sector, which was available for the benefit of all persons in the society. Now you see, like this information, this knowledge is flowing to just one company. So look at the developments, the ownership getting transferred. So at the same time, the universities are getting right to licensing of those rights on which they are getting that ownership. And that is what is happening. Like a lot of companies, they started funding your research, and they have started funding your research in return for the exclusive right to that research. So what is the effect? That if they have that exclusive right on the outcome of that research, on the output of that research, so obviously that information, that knowledge, right, which was that outcome of your research, that is not getting available to one and all in the society. So that is flowing actually in one direction towards that company. So these are the developments which had taken place because of the application of your IPR in the academic research, because of the legislation which was being enacted by the US Congress, and because of the conferment of that power to the universities in research in regard to the ownership of your IPR rights. Now, very interestingly, like many people have, I have seen like many people have appreciated this thing, like they are considering your university as something, energy, engines of economic growth, because these are actually, incurring money, right? So they are considering these universities as to be an engine of your economic growth. They are actually, hailing this surge of, patenting, licensing, etc., etc. Now, at the same time, uh, there are there are a lot of, people who are worried about the long term effect of this expanded patenting of that university. Now, is that clear to all of you? Like, we talked about that, transfer of that ownership, and now we talked about both the sides. Like, few people are appreciating, they are finding it that okay, this they are hailing this search in the, patenting and the licensing, and they're looking it as a great benefit to their society, and they're saying that okay, this university now has become an engine of your economic growth. At the same time, we have some other groups also who could find out, who could see that, long term effect of this expanded patenting on that, university. Now, in regard to that, uh, I am showing you a report that was being produced by the American Academy of Arts and Science, and the title of that report is Science as Intellectual Property, who controls research. And just have a look at the observation of that report, uh, of that American Academy of Arts and Science. The observation I have, written down is very clear. The observation says, as I read, that academic research has been a public resource, a repository for ideas, and a source of relatively unbiased information. Industrial connections blur the distinction between corporations and the university and establish a private control over a public resource. Are you getting my point? So, this is that exact finding of the American Academy of Arts and Science. They are saying that this is a public resource, and this is actually a repository of ideas and source of relatively unbiased information. So any kind of, industrial connection would be blurring the distinction between the corporations and the university, because we need to understand that we have researches, university funded, that university carries on research, and there are companies which are carrying on research. So a company based research and a university based research, the motive and the purpose of these two researches are different. When we talk about that academic research, there could be an industry based research as well. But when we talk about that academic research, so we must not forget that uh, 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 looking into this, academic research, our university traditionally does provide some kind of, intellectual commons. And mind it, intellectual commons means like in which your ideas, your discoveries of ideas and discoveries of different scholars, they must be made available for the use and benefits, of all members of the society. Ma'am, what happened again? What happened? No, no, no. No, no. Take it. So, like this, the American Academy of Arts and Science, we have a lot of groups who have voiced that similar kind of, concern in different forums. And I'm telling you that this university historically, traditionally has provided an intellectual commons. and that intellectual common would be, giving the different kind of, ideas and the discoveries. Different ideas and discoveries of different scholars have been made available in that intellectual commons, and which can be used and which can be beneficial for all members of that society. But what now we are seeing, as I have analyzed to you, that with this corporate funding, what is essentially emerging, that many academics, they are keeping their research secret, they are delaying their publication of the result until the companies could actually protect their investment. Because I have mentioned, like in the entire process now we can see that, commercial aspect, that profit motive of the companies, because because the university is licensing those rights. So the companies, the firms would be looking for to kind of, in getting kind of, benefit, profit out of this transaction. So there would be a lot of, restrictions on the freedom of academic research. So if this point is clear, I will go ahead and now I will talk about some kind of, illustrations to this, fundamental academic issue in questions of intellectual property and the academic research. Now, uh, this much I think is clear to all of us, like how this is encroaching into that freedom of that academy. Now, I'll give you some examples. The examples that will show that by transfer of this ownership from university professors to the universities, and thereafter universities having having gained this right of, licensing of those rights to the private firms, and also in the light that the private firms or the corporations, they have started funding your research. And when they have started funding your research, what would be the consequences? Let us have a look at this example. This is an example. That name of that professor, the original name of that professor is hidden, but he was a professor in the Midwestern Research University. And I will just share his story, like how this affected the entire paradigm of an academic research, because his research was being sponsored, was being funded by one corporate company. Now, this is just a fact I'm stating you, and you must understand. In the hindsight, you would understand that what is that implication of the entire story which I'm telling you in regard to Dr. Hamstrung. Now, Dr. Hamstrung, he was a professor, as I'm saying you, in one research university, and he joined a project, right? And the purpose of that project was to develop instructional technology. Now, we don't need to understand what is instructional technology, but the purpose of that research was to develop instructional technology. Now, instructional technology ki kya kaam hote hai? That instructional technology is very suitable for use with an equipment, right? Now, that instructional technology, if you impart that technology into that equipment, so that would be very useful. And that equipment which I'm talking about is being produced by that by a large technology company which is funding this research. So you look into that situation. Dr. Armstrong, he was a professor, right? And he got a research jahan pe he had to develop one instructional technology. Now that research is being undertaken or being funded by one company, a very large technology company, or the purpose of that, research was to develop instructional technology, and that instructional technology is very useful, very suitable with an equipment. Which equipment? That equipment which this large technology company is producing. So what happened, that when this proposal came and there was an acceptance of this proposal, the purpose was to develop instructional, technology. So faculty members, the students, the company officials, and the technical personals, they all discussed that project at length in a very open and free manner. So after the discussion, the research question looked very interesting to the professor and all other his associates, and the company also found quite exciting uh, um, uh, this prospect of this research. Now what happened? There was a twist. Both the parties were happy. The Hamstrung, he was very happy with that research questions, and that company was also very excited with that prospect. Now, when the equipment which I was talking about, I said that the purpose of that research was to develop one instructional technology which would be suitable to use with an equipment, so that when that equipment was brought in that campus, Dr. Hamstrung and others who were on the project, they were required to sign one non-disclosure agreement before they could see that equipment. Now look at this twist. So when that equipment was being brought to that campus, before they could see that equipment, they had to sign one non-disclosure agreement. And you understand that non-disclosure agreement would be containing few provisions which that person who has signed that non-disclosure agreement will have to comply with, right? Now, in that non-disclosure agreement, as you can guess it, like the first condition was that Dr. Hamstrung cannot discuss this project with anyone who is not on the grant, because that was a grant from that company, and the company uh, allowed that grant to Dr. Hamstrung and few of the persons in that university. So what was the first restriction? That Dr. Hamstrung cannot discuss this project with anyone who is not on that grant. And the contract also gave that company the right to approve publication. Now you look into it, that there can be several publications out of a research, but who is getting that right to approve that publication? That company is getting that right to approve that publication. So even if Dr. Hamstrung, he was, assured that company really, hold up anything like that approval which we have been talking about. So when everything seemed to be normal, Dr. Hamstrung, he signed that, agreement and began working on that project. Now look into it. It took just some time to understand and to look into the academic consequences of that agreement before it could become clear to all of us. Sorry. Now, Dr. Hamstrung, as I said, could not discuss his research with the colleagues with whom he usually used to discuss. First restriction, because he was supposed to discuss only with those people who could get that grant, who were being made part of that particular research. So although he had some of the colleagues with whom he could discuss, but effectually what we could see, that what he could feel, that his ability to exchange that information freely and his right to consult the best intellectual sources, that had been cut off substantially, because you see that restriction, he was not free to discuss it with anyone, right? He could discuss only with few people who were on that grant. At the same time, he could feel like his ability to exchange, because in an academic research you must have that ability to exchange that information freely. So he could feel like his ability to exchange that information freely, and his consultation with some of the intellectual sources, because everyone not was on that grant of that particular project, so that had been substantially cut off. And it also affected his teaching, because he was deeply engaged in that research, and every time that research was going on in his mind, but he was not allowed to discuss it as an example in his class. So that was again affecting his teaching. And what is very interesting, because he could discuss his research with two of his doctoral students who were in that group, but he had other three doctoral students with whom he could not discuss. So he had no other option, but he continued to fulfill these terms of this non-disclosure agreement, and ultimately he found himself increasingly silenced. So that very articulate professor, he ultimately lost his verbal fluency. So this was that effect, right? And the second incident which I have referred, as you can see on the slide, is the Scripps Research Institute, California. That is also representing the same kind of fact, because this Scripps Research Institute, that was an institute in California, This institute, entered into a contract with a pharmaceutical company whose name was Sandoz, and the same kind of contract, that non-disclosure form was being executed, and that case went to that extent that this was that company which used to give permission that who all can enter into that building where that research was going on. Permission वगैरह तो है ही, because without the permission of this company, that is Sandoz, the researcher could not publish any article, could not go for any kind of publication of that research, right? At the same time, this was that company who is to instruct and who's to give permission that who all could enter into that building where that research was going on. Now, against the backdrop of this incident, you can look into the severity of these incidents. What is happening in the name of licensing, in the name of the ownership, and in the name of the funding of that research? What is happening? This director of this National Institute of Health, he at one point of the time, especially after the incident of Scripps Research Institute, California, it was widely publicized. So he himself testified at a congressional hearing, and he agreed that this agreement, that agreement to which the Scripps Research Institute entered with Sandoz, this agreement actually forbade the free exchange of ideas. And he admitted that this was against the spirit of the science, and probably this was against that law. So in the hindsight, you can see like how this funding of the research by the private entities, by the companies, by the corporations, this shift, that evident shift of that intellectual property rights of the professors to the university, these all things are actually how it is hindering the growth of academics in the academic research. Now, I stated the very purpose of academic research, isn't it? I said that when we look into this academic research, so this is actually providing an intellectual commons in which your ideas, your discoveries have been made available for the use and benefit of all members of the society. So now you have two extremes. You look at the things which are happening, and you look at the purpose of the academic research. The purpose of the academic research is to create an intellectual commons. I repeat, the purpose of your academic research would be to create an intellectual commons. What is that intellectual commons? That every kind of ideas, every kind of discovery by different scholars must be made available. Why? Because this must be for the use and benefit of all members of the society. This is the purpose of your academic research. But at the right hand, you see what is happening. The professors, they could not even go for publication of some of the papers out of that research because their permission had to be taken from that company. So that company which was funding that research was controlling the entire affairs of that research, which was definitely hindering the academic growth. Because that free exchange of information, that free exchange of knowledge is very essential element for your academic growth. That freedom has to be there. If that freedom is not there, if that researcher, if that academician, if that professor does not feel that freedom, he feels suffocated with this kind of conditions to be imposed, because he can. I just gave you that example of Dr. Hamstrung, that you just look into that situation, that he could discuss with two of his doctoral students, but not to other three doctoral students. He could not mention of his research, and he could not give any example in the class because there was a restriction. He was not allowed to talk about that research in the open public forum. That is what now you see, looking into the purpose of that academic research, right? Looking into that looking into that purpose of that academic research, and also looking into this thing, like what is happening in the name of your commercialization of your academics, you can see that there is a shrink to your intellectual common. Can't you see that there is a shrink to your intellectual common. That intellectual common, jahan pe your knowledge, your ideas, your resources must be made available for the benefit of all members of the society. But in the context of this funding by the private entities, now this knowledge is flowing towards one direction only, and that too with a lot of restrictions on the freedom of the researcher and the academicians. So definitely there is a shrink to that intellectual common. And if you look into that shrink to that intellectual common, so you would see that three important area of concerns are coming out. One is, if you look into the entire development, right? If you can understand what is that shrink which is taking place in that intellectual common, you would be identifying three very major areas of concern. The first one would be your financial incentives. Why it is so happening? You see that why it is happening, why we are taking fund, and why the universities are going for licensing of these IPR rights. There is a financial incentive. There is that financial incentive to that extent that many research scholars, many scientists, they are now only going for a kind of commercially viable projects, because the university would be sharing a substantial portion of royalty income, the royalty income which is generating out of that, patenting, licensing, etc., etc. As I told you people, like in every university, in every big university in US, there is an office which is devoted in this task of patenting, licensing, any kind of transfer of knowledge, etc., etc., from the university to that private sectors, to the firms, to the companies. So why this is happening? This is because of that huge amount of money which that company is ready to pay, and the university is also ready to share a substantial portion of that royalty with the faculty concerned. So that sorry, financial incentive is there. But financial incentive, when we look into this financial incentive, there are two gray areas that you must understand. In the name of the financial incentive, as I have stated with those two incidents, the first incident of Professor Hamstrung, so there is an increased secrecy. Why there is an increased secrecy? Because like the the scientists, these academicians, they would be keeping their findings secrets for a longer term that they otherwise do. Why it is happening? You look into it, like this secrecy, that maintaining that secrecy is part of your research. So many times we keep our research topic secret, or we don't publish our early finding, and we keep our early findings confidential, etc., etc. This is why, because this is just to prevent any other person from poaching their ideas, isn't it? Not beyond that. But your concern for monetary benefit, that financial aspect, would make you wait for the publication, would make you delay that publication of the research for an indefinite period of time. And you would come across a lot of cases where there is a complete prohibition of the publication of that work, because there is a very huge commercial value in it. So we look into that financial incentives. We understand that there is a kind of financial incentive, because of which lot of scientists, lot of researchers, lot of professors, they are now inclined towards this your commercially viable project. But when we go deeper, you can also come across that increased secrecy, and in the name of that secrecy, they are actually hindering that growth, that academic growth in that research. And the second one is the conflict of interest. It's very interesting, because there is conflict of interest, and there have been a lot of cases when you come across this conflict of interest. And in order to go with that interest of some of the persons, you will see that you are actually jeopardizing that interest of the researcher, research output. Now conflict of interest may, the first example could be that when the faculties, they have some outside financial interest. So what they can do, they can bias their research in the ways that would serve their purpose, that would serve their interest, even at the expense of the credibility. So if one faculty or if one researcher, if he is having a kind of outside financial interest, so there is a likelihood that he may bias his research in ways that will serve that interest. The second example of the conflict of interest would be like uh, uh, many a time you would see like the faculties who having this outside financial interest, maybe as an owner of that consultant firm, maybe as a manager, maybe as a consultant to that private firms, they may shift the ownership of certain IPR from the university to the firms. And this is very interesting. Many of you may have come across this kind of incidents. This is exactly happening in a case where you see like a value of your particular invention may lie more in the trade secrecy. You take an example of your any research in the genetics. So commercial value of that research would be resting on the production process. If you are into research of genetics, you would see that the commercial value of the entire product would be on the basis of your production process, and that production process, you must know, that cannot be patented. For example, if you take that example of gene chip engineering, that is a production process which is producing your any genes or any reagents, etc., etc. Now commercial value of uh, commercial value of the products, that can be protected only if these processes can be held secrets. So it cannot be allowed to be published. Are you getting my point? So the product, even if you are going for patenting of that product, the entire value would depend on that secrecy of your production process. So that trade secrecy has to be there. So if you can keep it secret, so that production value will be there. But if you cannot keep it secret, that production value of that product will decline. So in a lot of cases, you would see that the faculties who have that outside interest. Take an example, if I'm a researcher and by virtue of the law, if I, because in US there are laws which would allow a researcher to become the owner or to become your consultant or to even become the manager of your private firms. So if supposedly I am the manager of a firm where my university has my university has licensed a patented rights, and I know, like, if I'm going to I'm carrying on a research, and if I'm going to disclose that process, so that will have a diminishing effect of diminishing that value of my product. So I'll never disclose that product process. Are you getting my point? I'll never disclose that process, and I'll never go for publication of that process, because I have an interest, because I am the advisor, or I may be the owner, or I may be the manager of a firm to to whom that university has given a license to that product. So this can happen in kind of different researches, that conflict of interest is there. Now there are other 2 points. I'll quickly sum up these 2 points, that is threat to collegiality and impact on the governance. As you understand, that when we look into that entire process, there is a threat to collegiality, because we are apprehensive of the disclosure. So we start ignoring our colleagues, and what happens so many times, the researcher would be restricting the size of my research team. I may restrict my size of my research team because I am scared, because I am apprehensive of the fact that more and more people, if getting engaged, that would minimize the dispute over the claims to inventions, right? Sorry, that would maximize the disputes. So that threats to collegiality is there, and obviously impact on the governance is there, because the entire mechanism now getting commercialized. So there is a sector in the university who would be looking after all these kind of inventions of the professors. So there is a shift of power from the faculties to the administration. So in that process, you will see like there is an conflict between these two existing groups of that people, and that is impacting that governance. So these are the different areas of concern when we look into that commercialization of your research matter. So in the end, what I feel like what is very important for us, that we must understand, it is very important for universities to recognize their mandate to conduct free and open research and maintain an environment of unrestricted exchange of ideas for the greater common good. So if we intend to adhere to this purpose, to this pious objectives and aims of that university, so we need to look into the kind of the mechanism which is now there existing by making that research commercial. So with this, I come to the end of this discussion. Thank you.
Thank you so much, sir. Sir, we have question answer round. So
Yes.
I'll just start with the first question. So first question is, how is the rise of green trademarks influencing the commercialization strategies of environmentally focused research initiative globally?
Yes. Can you repeat this question? Just a minute.
Yeah, sure, sir. How is the rise of green trademarks influencing the commercialization strategies of environmentally focused research initiative globally?
Okay. See, I have discussed about the commercialization strategies of environmentally focused research, right? Now, the any kind of rise of these trademarks, right? That that definitely end of the purpose. The purpose is to gain profit out of it, right? So there is a commercialization, right? Now, for any kind of IPR, that is intellectual property rights, it's not only the trademarks, right? As I have explained you people, like for any kind of intellectual property rights, if you want to incorporate into that academic research, so there is an inevitable commercialization, even if this is environmental friendly. So there are a lot of measures which been taken up for making environment friendly trademarks, etc., etc. But end of the day, you will see that there is a commercialization of that IPR rights.
Thank you so much, sir. Next question. Do non-fungible tokens, NFTs, play a significant role in protecting trademark associated with digital product derived from research?
No. I'm not quite sure of this thing, but I'll have to look into it.
Okay. Next question. So, how can researchers balance the commercialization of their research with ethical considerations related to trademark use?
See, the balance has to be looking into both the aspects, because I said that commercialization. Uh, I never said that commercialization cannot take place. There has to be commercialization, because lot of times what we have been seeing, like we are running out of that fund, right? We are not getting government funds, so we need to look into the funding from the private agencies. And when we look into this funding of that private agency, so there is automatic commercialization of that research, right? Now your ethical consideration related to trademark, so it needs to, I mean, what, how it is to be balanced, like it depends on the wiseness of a researcher. Like, your ethical value, to what extent to justify doing something, is completely somebody's own call. Are you getting my point? So for any kind of like balance which we intend to make there between this commercialization and your consideration related to any IPR rights, so there has to be a balance. I understand there has to be a balance, because as I told you, like, commercialization could be the need of the art to some extent, but that commercialization cannot take place at the cost of the very basic aims and objectives of the research. So that free flow of knowledge and information should not be interrupted. There can be a restriction to some extent, but not the entire process has to be dominated by that, funder.
Thank you so much, sir. As I think we end of this session, and on the behalf of Department of Law, Integral University, Lucknow, sir, we conclude our today's session, and I would like to take a moment to express our sincere gratitude to Dr. Prasanjit Kundu, sir, for his esteemed presence and valuable contribution to our FDP 1 month FDP program. Sir, expertise on the topic of commercialization of research scope of trademark right was invaluable to our participants, sir. Thank you so much, sir. We are truly grateful for your time and dedication in sharing your knowledge and insights with us. Your contribution has undoubtedly enhanced the quality of our program. Thank you so much, sir, for your presence, sir.
Thank you so much. Thank you.
Thank you, sir.